Welcome back, everyone. I'm very happy to introduce our next speaker, Catherine Templin, former Senior Compliance Manager, Bilfinger. She is a compliance expert and a lawyer as well. She was responsible for implementing a compliance program within Bilfinger Teboden Group, working on some legacy compliance issues with the U.S. Department of Justice. What I find interesting about Catherine's background is that she started in South Africa during the apartheid regime, and this is what kind of inspired her to have an enduring interest in human rights law, which connects to the theme that she is presenting today on. So thank you for being here, and I look forward to hearing your insights on human rights and to be inspired myself. Thank you.
Thank you, Robert. Very nice introduction. Good morning, everybody. There are some familiar faces. It's nice to see you all again. I wish we could do it with a cup of coffee, but I think we're learning to adapt to this new virtual environment very well. I'm going to jump right in because I've got quite a lot of material to cover, and I have a confession. Let me just move to, there we go. Got to get used to this technology too. I took my title from the title of the recent OECD guide, which came out in September, Connecting the Anti-Corruption and Human Rights Agendas. The guide doesn't suggest that we should merge these two agendas, rather that we should look for the connecting points. So I started thinking about these connecting points and got back in touch with my roots and why I went to law in the first place and how I ended up in compliance. And so what I'm going to share with you today is the results of my own assignment to myself. In the companies where I've worked in the past, human rights law has always been a soft topic. It belonged to corporate social responsibility or was tucked away somewhere else. But this is changing. We're seeing globalization, the effects of new non-state actors, social media, you know, everything that's changing. And this is all increasing the political and economic risks and costs of official corruption. Soft law is becoming hard law, and there are so many resources out there. I'm willing to bet that most companies do not have an adequate grip on this topic. Although when we go to questions in 25 minutes, I'd be very interested to hear other companies' experiences and how far you are, how mature you are on this journey. The OECD guide is a very useful place to start. It helps us orient ourselves between the two agendas in terms of focus, scope, approach, and organization. Anti-corruption is typically focused on criminalization, perpetrators, it's regulated, human rights is much more diverse, it's much more of a nice to have, it's harder to enforce. You've got a fairly well-defined definition of corruption. On the other hand, human rights covers a wide range of areas and is less clearly defined. You also have different types of stakeholders in both areas, and you see in organizations that each of these topics is very differently organized. So I was curious as to why these two agendas have been so disparate for so long. Starting out in my career in South Africa during the apartheid era, I was involved in an investigation into incidences of violence and oppression by the police and security forces in a homeland called KwaNdebele. The locals who lived there had been forcibly removed. There was forced removals legislation at the time. They'd been bundled into trucks in the middle of the night by the security forces and moved to a deserted area where farming was difficult. They lost their homes, their schools, had to leave the grave sites of their ancestors. They lost everything. Some people even lost their lives. These people had owned this land as a tribe for over 100 years. So numerous human rights were affected by this action. The right to own property, the right to life and health, the right to family life, and so on. You could put up a whole list. But the procedural and individualistic rights of the oppressors weighed more heavily than those of the oppressed. Their land was given to white farmers, and they had no rights that they could assert. Now, all this happened in the 70s and 80s, and apartheid is gone, but the legacy lives on. And I wondered how it has come that 30 to 40 years later, these two issues are still treated as separate and disparate. Well, today I'm talking to you about a trend. So in order to understand it, we need to put what's happening now in its historical context. And this is the advantage of being at home during a pandemic. You actually have time to do homework and answer the questions that have always been at the back of your mind when you're giving compliance training to people, but never had the time to actually research. So starting at the right-hand side of the slide in 1989, this is 12 years after the FCPA was enacted. What I discovered was that the real impetus for the anti-corruption agenda came from the World Bank in the light of its mandate in development policy. With its good governance agenda, people began to see, unbelievably for the first time, that corruption is a major impediment to the success of economic reforms. So corruption emerged as a governance issue in the World Bank and then the IMF to a lesser extent. Now, going back to 1948, on the other end of the slide, post-World War II, we see that corruption had been on various agendas since World War II, but in separate contexts. For the developing countries, anti-corruption activities were pursued within the UN as a means to undo the unfairness of colonialism. For developed countries, this was addressed via the OECD as part of the foreign aid agenda. Why was this? The OECD, as a standard-setting organization, was established in the 1960s after the Marshall Plan to provide post-war foreign aid by developed nations. So this foreign aid generosity grew into what we now know as the development agenda. Despite some attempts to address corruption and bribery, like the FCPA, it had been mostly considered a necessary cost of doing business. Corruption was even seen by some as beneficial, cutting bureaucracy in underdeveloped nations. This attitude was strongly influenced by the Cold War at the time. The ideological agendas of the USA and the USSR overshadowed corruption. And there was this reluctance by Western governments in particular who were to criticize Africa of being racist. And so there was this kind of optimism that developing nations would grow organically and that corruption was a necessary path in their development. Alas, as we all know, once corruption takes root, it's very hard to eradicate. In addition to these historical facts, there are a number of theoretical arguments that have also stood in the way. A couple of years ago, Anthony Spalding and Matthew Murray wrote a great article in the FCPA blog suggesting that people have a fundamental human right to live in a society free of official corruption. Imagine what that means. If we consider the historical developments, it's easy to see how 4 theoretical arguments have prevented us considering a society free from official corruption as a human right. The human nature presumption. It's unavoidable. That's who we are. Cultural relativism. Oh, it's a cultural thing. We can accept corruption because it's part of their culture. Convention language. You can't read into any of the human rights conventions that anti-bribery is a human right or the other way around. And then there's the final argument that corruption is merely a means of violating other rights. And this, incidentally, is the view of Transparency International. But these 4 arguments have been used to deny basic rights like freedom from torture and slavery and so forth. And Spalding and Murray bring a number of really good arguments to the table, showing that human rights evolve organically. Think about data protection. That wasn't a human right in 1948. It is now. They transcend political, cultural, and economic rationalizations of misconduct. If you were to regard the absence of official corruption as a human right, you'd be giving that definition more normative weight. So if you see the struggle against official corruption as like fighting a mutating virus, what you'd be doing is treating the cause, not just the symptoms. Make it a law. And finally, that one of the strongest arguments they come up with is that they show on the basis of a number of examples that prevention of official corruption is a precondition to fulfill human rights. So they effectively turn that means argument on its head, and they show that you can't have human rights if you tolerate corruption. Now, what else? Soft law is turning into hard law. If we look at all these legislative initiatives since 2011, when the UN Guiding Principles on Business and Human Rights came into force, every single one of these pieces of legislation, either directly or indirectly, makes a clear reference to human rights and or corruption. And the links and the overlapping points, the connecting points, are becoming clearer and clearer. There's something else that's developing. The law on diffuse harm is evolving. Slightly difficult concept maybe for the non-lawyers among us. Transparency International released a recent report called Exporting Bribery. And what they say is that lawmakers must start operationalizing certain concepts, social damage, collective damage, diffuse harm, when they're looking at compensation in foreign bribery cases. Social damage is often associated with compensation for damage to the public interest. So that includes damage to the environment, to the credibility of institutions, or collective rights such as health, security, peace, education, good governance. It's sad to see that only a few FCPA settlements to date have resulted in restitution, but the law on diffuse harm is evolving in many countries in the corruption context, as it did when environmental crimes first became actionable. So, to take an example, a river gets polluted. Downstream, you have harm suffered by hundreds, thousands of people who can't all individually bring cases to court. So, legislatures started saying, okay, if one party sues for collective damages on behalf of all those victims, then all the victims can benefit, and we only have to test the case once. This is something you might want to discuss with your boards in terms of emerging risk. We're all at home at the moment this year, but these developments are happening very fast. Costa Rica and Peru, those are the flags of the two countries at the top of the screen, are two pioneering countries in this area. They allow compensation claims by the state for social damages or economic harm to the state resulting from official corruption and bribery. The flags on the bottom, France and the Netherlands. The Dutch public prosecutor has recently released its revised framework for offering large settlements. So this is becoming a sort of a, the prosecutors are developing tools to be able to use these terms more practically in settlement cases. Another topic, locus standi, for the non-lawyers, it basically means legal standing. It refers to when complainants are legally entitled to bring a case to court. And as you can imagine, compensation of victims in civil and criminal corruption cases, both of them, can largely depend or entirely depend on their recognition of their standing. Some laws require you to prove that you have personal injury or damage. But there are already many laws that recognize representative organizations. For instance, in France recently, TI France filed a complaint in a money laundering case, acting in the collective interest, because they said we're an organization that tries to foster awareness of bribery and corruption, and therefore we have an interest in seeing this case prosecuted. Finally, measuring damages. That's always a difficult one. Bribery, corruption's been committed. How do you measure how much damage has been suffered? But it's not impossible. Transparency International suggests that for social damages, victims should get at least the disgorged profit plus the costs, the court costs. And they are saying, we would like to see formulae being developed for calculating social damages. So watch this trend. It's going to develop further. . Only a few years ago, Corporate social responsibility reporting, CSR reporting, was the norm. It was seen as voluntary and it was limited in scope. But we're seeing a move towards pushing corporate actions beyond minimum standards. We're seeing a move towards environmental, social, and governance reporting. Not only regulators are asking for this, but investors are expecting it increasingly. We're moving to from transparency regulation to mandatory substantive due diligence. There's action. There's still a lot of window dressing, but it's changing. The Big Four, Deloitte, PwC, Ernst & Young, KPMG, jointly published their ESG reporting standards in September called Measuring Stakeholder Capitalism. On the financial and non-financial reporting side, we're seeing EU initiatives. The EU Sustainable Finance Disclosure Regulation 2019 was incidentally updated a year after its release to include the explicit statement that it respects fundamental human rights. And on the non-financial reporting side, we can expect to see the Non-Financial Reporting Directive being revised in 2021. Okay, so your company is facing increasing reporting requirements, but what about the content? Where do you start? What do you have in place at the moment? What needs to be developed further? To help you understand how a number of key resources fit together, let's start by looking at the UN Guiding Principles on Business and Human Rights. As you recall from that time slide, this is the authoritative global standard on the respective roles of business and government in helping to ensure that companies respect human rights. It was adopted in 2011, and it's based on 3 pillars: protect, respect, remedy. Everyone has a role to play in this. It's a big catalog of human rights, and it may be useful to start with this document to have a look at what you have in place and what your company might still need. It'll help you structure your scoping and framing. I've also put together a kind of a resources kit, a starter pack of resources that you might find helpful. Obviously, the International Bill of Human Rights is a really good place to start. On the bottom, we've got the UN Guiding Principles on Business and Human Rights, the GPs, 2011 I just mentioned. On the top right, we've got the OECD guide that I started with. The bottom left, the 2030 Agenda for Sustainable Development. This is the impetus for a lot of recent initiatives. We're seeing legislative initiatives and non-legislative initiatives. So this is a go-to framework for anything that you're doing. I'm not going to go into the ILO Multinational Enterprise Declaration below, but the critical thing I want to look at today with you is the OECD guidelines for multinational enterprises, also from 2011, and associated with that, the OECD Multinational Enterprise Due Diligence Guidance, which came out 7 years later. Now, remember from the beginning, we've got the UN Guiding Principles that was more or less came out of the developing nations agenda. And then we've got the OECD guidelines, which is more focused on business, multinationals, because that came out of the agenda of the developed nations. Right, the OECD Due Diligence Guidance for Responsible Business Conduct. This basically covers 6 chapters for responsible business conduct in the OECD guidelines for multinational enterprises. I know getting your head around all these names and titles of guidances, guides, and it's a lot of terminology, and they all sound quite similar. But this is a really important one. It's based on the OECD Multinational Enterprise Guidelines. It's like a sandwich. You've got the UN Guiding Principles, that's your slice of bread, and then you've got the OECD Guidelines for Multinationals, that's your ham, and then on top of that, you've got your cheese, the OECD Due Diligence Guidance. You can't have the sandwich without the cheese. Due diligence is key. I want to share with you 5 aspects or key ways in which human rights due diligence differs from traditional risk management or third-party due diligence as we know it. First of all, it involves an outward-facing risk approach. You're not just looking at risks to the company itself. You're looking at risks that can be caused by the company or other actors all the way down the supply chain and that can affect people that are associated with your supply chain. Human rights prioritization is different to regular risk management because the severity or the potential irreversibility of the harm weighs more heavily than the likelihood of the harm occurring. You're dealing with multiple processes and objectives. It's much broader than traditional due diligence or know your customer procedures. It's an informed process. It may involve local stakeholders like local NGOs, foreign governments, local foreign governments, vulnerable stakeholders on the ground. So you may need local expertise to do this. And it's also a much broader process. You start with a baseline and then you you follow an iterative process with increasingly in-depth assessments. So you can tell already you need a different kind of skill set here, different resources, different knowledge to be able to do this. But there's another process, so we're building on our sandwich here, that is equally critical, and that is the human rights impact assessment. Conducting a human rights impact assessment is an integral part of the UNGPs. The UNGP author, John Ruggie, ran out of time after 6 years, and so he never managed to develop a methodology. But fortunately, the Danish Institute of Human Rights was working on an HRIA. Now, there are a number of other methodologies available, but this one is good. It consists of a guidance tool, a guidance and a toolbox. So you've got the quick check desktop tool, and then you've got the human rights compliance assessment, which translates over 80 instruments, human rights instruments, into practice, into company policy, procedures, and performance. Now, for the last 5 to 10 minutes, I want to do a brief dive, not deep dives, very shallow dives, into 4 burning platforms: child labor, diversity and inclusion. I want to talk a little bit about privacy and algorithms. And finally, I want to leave you with some thoughts on government actions to implement emergency measures under the COVID crisis. Now, starting with child labor, I'm going to give you a story about Nestlé. I'm not a Nestlé insider, so this story comes with a disclaimer. And I see we actually have someone from Nestlé in the audience today. So if David is here this morning, please stick up your hand or put a message in the chat, and Robert will interrupt me if you want to add to something that I'm saying. So let's take a look at one industry leader's approach to managing child labor in their supply chain. Nestlé's Cocoa Plan illustrates the kind of actions that they've implemented. Getting a copy of a child's birth certificate so they can attend school, providing children with school equipment and uniforms, enabling mothers of children at risk to generate their own income, setting up groups to carry out hazardous tasks, addressing root causes, training farmers, etc., etc. This requires intense stakeholder engagement on the ground by skilled strategic relationship managers, and it requires extensive resourcing. These interventions are what we call non-judicial redress mechanisms. They have the potential to complement formal government authority by using different kinds of leverage. We talk a lot about leverage in human rights due diligence, to generate new commitments, new relationships, and to generate changes by companies along their supply chains. But they cannot replace effective, legally binding mechanisms. In 2014, Nestlé commissioned a report from the Fair Labor Association and found that despite all their efforts, that child workers were present at 7% of the farms. Awareness of farmers amongst farmers of Nestlé's code of conduct, which obviously prevents child labor or prohibits it, that was low due to lack of interest or time. Farms lacked any kind of age verification system, etc., etc. So human rights due diligence is hard. It's really hard. In-house, you've got a more or less finite audience and defined processes. But in all human rights areas, we're seeing the span of control that companies are expected to have in external compliance increasing along the supply chain. And how we're supposed to do this in a pandemic is anyone's guess. So a typical question you might want to ask your board or address in your organization broadly at the moment is, where are the skills, the tools, and the experience needed to manage this increasing compliance burden? You may need local expertise in dangerous and remote areas. If you're looking at conflict minerals, you may need information on smelters who are 10 steps removed from your company. You can't do this alone. What we need is legislation and mandatory compliance. In December last year, a number of chocolate producers sent an open letter to the EU advocating child labor due diligence regulation. So hopefully that's pending. In the meantime, some countries have taken action. The Dutch Child Labour Duty of Care Act was published in November last year, and it's expected to enter into force in 2022. Companies not only have to report on due diligence on child labour, but they have to do due diligence, they have to prevent it in their supply chain, and they have to take action if they find evidence of it. What's interesting to note is that in this act, companies are expected to draw up a plan of action, and there is an explicit reference in the act, which is quite unusual for a piece of law, to the ILO IOE Child Labour Guidance Tool for Business. Yes, another guidance, I hear you say. Two, in fact, because the Child Labour Guidance Tool is based on the Handbook for Employers and Business in Combating Forced Labour. So you've got the link to forced labour and modern slavery there. What we'd of course like to see, ideally at EU level, is regulation that addresses or covers all internationally recognized human rights, not just one topic at a time, because if you address all of them, you can address cross-cutting issues like child labour, modern slavery, and possibly conflict minerals. In addition, perhaps I'm too optimistic, it might cut down on the number of guidances that we have to work through. Another topic. I cannot not discuss the topic of diversity and inclusion when discussing human rights and corruption. Diversity is being invited to the party. Inclusion is being asked to dance. A very nice quote from Verna Myers, who's a specialist on the topic. But I think we're finding that this two-dimensional approach, we often talk about diversity and inclusion in one breath, is actually quite limited. In this diagram on the right, you'll see a third component, equity. And in the overlapping parts of the circles, you can read what happens when you focus on only two of the three. And the goal of incorporating all three is obviously to foster a sense of belonging within the organization. And I think this model is just as useful outside the organization, because if you think about it, all defined human rights directly or indirectly aim to respect and protect diversity, inclusion, and equity. So why shouldn't our DI&E programs extend therefore beyond the organization to customers, stakeholders, and others throughout the supply chain? There are two final seeds of thoughts that I want to plant with you today. And perhaps the concept of equity ties into the next one nicely. Tomorrow, David is going to talk about ethical use of data and technology, so I'm not going to steal the show there. But remember how I was saying that human rights evolve organically? Well, privacy is a perfect example. It started with the Universal Declaration of Human Rights and the right to respect for private and family life, and that grew to include home and correspondence and the protection of individuals with regard to automatic processing of data. Then came the Charter of Fundamental Rights of the EU, which explicitly raises the level of protection of family and private life and personal data to that of a fundamental human right. So where's this trend going next? We're not just talking about our data that's at stake. Any of you who've seen the movie The Social Dilemma will know what I'm talking about. One story I recall is that the young Silicon Valley coders who developed a lot of the technology that we use were never trained to think about the mental health effects of what we call positive intermittent reinforcement, that continual push messengers and reminders on your phone, the things that cause us to become addicted. So we're seeing in the digital world more and more pressure to produce the currency of attention. How long can Facebook or Candy Crush keep your attention? We build the algorithms on past behavior to predict and model and influence future behavior. There's a lot of manipulating going on here. And this raises many ethical questions, of course. That's for David to address, but I leave you with this question. What fundamental rights are affected here? Do we need to define a new fundamental human right? My final thought I want to leave you with today, and that's something that affects all of us as individual citizens, whether we work in an organization or not. Rights are always balanced by duties. If we want to have the rights that I've listed on the left, we need to have a government that observes its respective duties. So what happens when a pandemic strikes? We either flee, we can't flee this one, or we freeze or we fight. So government wants to be seen as taking action. It has to do something, implement measures, right? Well, it turns out that emergency measures, many of them, have a big impact on our fundamental rights. So it's with good reason that these measures, however essential they may be, require legitimacy, an act of parliament. And has probably happened in many countries, emergency ordinances have been enacted and implemented at municipal or regional level without the necessary constitutional legitimacy. How do we feel about this? How do you feel about this? I had a colleague a few years ago who loved to say, there is nothing so permanent as a temporary solution. In other words, allow the government just this one time, because it's temporary and it's so urgent, to breach the Constitution. What happens next time our constitutional rights are threatened? And here's my key takeaway. What I've been talking about, in effect, is someone's idea that we need to protect human rights, someone else's idea that we need to prevent corruption. And as it turns out, if you can figure out what elements of both will benefit your organization, its people, and its stakeholders, you may very well become to be perceived as visionary. Watch the trends, pick out what your organization needs, and dare to be visionary. I've got to go back.
I see the applause coming in from the audience. I don't know if you can see that as well.
Very nice. Thank you, everybody.
Laurent is saying, Benjamin Franklin once said, those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety.
That's a perfect quote. Thank you for that one. Very nice.
And Abiola is saying, a very fragmented landscape, Catherine. From a budget perspective, what is a key priority to start with?
I think that depends on your organization. You know, your existing risk matrix will probably tell you where to go. And I think you need to discuss this with people. And scoping and framing is the most important thing that you can do, because with the COVID crisis and the coming implementation of the conflict minerals law within the EU in January, what are you supposed to do if you can't travel, you can't fly, you can't be on the ground? So there's some practical considerations. I think that using the UN guiding principles is a good place to start, just brainstorming and going through that whole list of all the human rights that there are that have been defined and deciding what touches, what affects your organization.
Okay, and any other questions from the audience? would be interesting to hear from the audience if any of you have been working on implementing a human rights agenda in your organization. Where it's found, is it covered by compliance or corporate risk? It would be interesting if anyone could share their experience. Feel free to raise your hand, or you can type a question or a chat to be involved in this question. It's still something that I get the feeling that not a lot of companies are too far along on, but maybe I'm wrong. Maybe it varies depending on legislation in different jurisdictions. I'm not sure, but
I think a lot of companies still need to wake up. You know, we're still assuming that we're in the corporate social responsibility world of voluntary, nice to have, and it's really difficult. I was attending a webinar last week by PACT on the work that they do in the area of conflict minerals. PACT is a non-government organization that addresses issues affecting the poor and marginalized. You know, they're taking 2 days to get into the jungle through mud landslides and dealing with warlords fighting over territory, situations that are changing every day. Not every company has to deal with this kind of thing. So, you know, there may be companies that are more focused on building up a diversity, inclusion, and equity program. And I see many companies forming D&I boards or committees, and I've often wondered whether the right expertise is in these boards. I feel out of my depth. I have family that lives in the States, where companies are a lot further ahead on this topic than we are in Europe. And you find that you need to develop a language with each other to discuss these kinds of topics. So for a lot of companies that don't have big, dangerous international operations, that might be a key place to start. And you might have more in your company than you realize. I suspect that looking at human rights as a whole, that a lot of these topics are scattered and dealt with in various pockets and areas in the company.
And we have a comment from Christina from Bertelsmann. It is covered by their compliance department. We have included human rights violations as compliance violations that need to be reported to the compliance department. There was a comment from Kurt as well. He mentioned he could shortly talk about his company, TVH's practice. He is speaking, I believe, tomorrow. But yeah, Kurt, if you'd like, you can raise your hand. We can bring you on stage if you'd like to briefly talk about your company's practice. Let me see if I can find you in the audience here. I can invite you directly. 1 second. I think, yeah, I don't think he's connected exactly at this moment. I don't see. Yeah.
See his hand raised.
Well, while we wait for that, if there's any other comments or question, I think he's here. Let's see.
Hey,
hi, Kurt.
Good morning, everyone.
Good morning.
Hi, Kurt.
Nice to see you, Catherine. Was a
Likewise.
very inspiring speech again. Just wanted to comment that, for instance, TVH, we are a family business, taking good care of your family and then seeing your family not only as your employees, but seeing it as the broader community is something that's in our DNA. However, what we lack or what we can grow in is formalizing all of this and actually pointing out what specifically is the topic we can do the most on, or where we have most of the impact on. And actually, we created a small group of people, which consists of myself, the CFO, our financial director, and our facility people that do environmental health and safety. We are actually doing now an SDG assessment in order to see where we have most of the impacts playing, in order to choose the measures where we actually can do most with. So we have already things in place, but we believe by looking to it in a more strategical way, we can do more. Let's say it like that. Okay.
I think that's a nice approach, because it combines the nice to have, that positive initiative that always was associated with CSR and human rights, doing something proactively rather than reactively on the basis of legislation and regulation, which is getting stronger, but it's not that strong that we can expect a great big increase in regulatory risk in the coming months.
Okay.
Good to hear.
Okay.
Thank
you can kick me out again, Robert.
We'll see you again tomorrow. And earlier, if you have any other comments during other sessions. And anyone else who would like any final quick question, we're a little over schedule, so unless there's any final quick comment or question, let me go ahead and thank you, Catherine, for a great keynote.
Thank you, Robert.
Presentation.
Thank you, everybody.
I see the applause coming in. Thank you.
Thank you.
So we now have our first coffee break. We shall return for the next presentation at 11:15. So please let me invite you to take a chair. Click a chair from any of the tables that you will see shortly, like you did in the morning. But if you don't know how it works, you look at the round tables, you click on a chair, and then you can meet other people, and you can benchmark and discuss the event in detail. And it's a lot of fun. It's very spontaneous. So we hope to see you there, and we'll be back in 30 minutes. Thank you again.